Good morning, everyone. Welcome. Let me ask you all to take your seats as soon as you can. I'm Scott Carlson. I'm the Associate Executive Director for Global Programs at the ABA. We're delighted to have all of you here today and online. This is our first ever ABA event on people-centered justice. And what we've attempted to do is assemble thought leaders, both international and domestic, to describe some cutting-edge work in the justice sector. During this difficult moment in world history, we hope you all will be inspired by the work that you hear about today. But before we start, let me thank George Washington University, the dean sitting over here, for hosting us today in this lovely facility and making this online experience possible. So we have a packed schedule. We're going to dive right in. First up is Dean Morrison of GW Law. He's responsible for creating a wide number of pro bono programs engaging students on a variety of public interest topics. This doesn't come as a surprise. For most of his career, Dean Morrison worked at Public Citizen in the litigation group, which he co-founded with Ralph Nader in 1972 and directed for over 25 years. And I was a student intern in '85 at Public Citizen, but I don't know if we ran across each other. He's argued over 20 cases in the United States Supreme Court, including one of my favorite con law cases, INS versus Chadha, striking down over 200 federal laws containing the legislative veto as a violation of separation of powers. He currently teaches civil procedure and con law here at GW. He's a graduate of Yale and Harvard, served as a commissioned officer in the United States Navy, as well as an assistant U.S. attorney in New York. Give a welcome to Dean Morrison.
Thank you very much and welcome here. I am only an associate dean. I am not the dean. You will meet our dean if you did not meet her before at lunch today. So glad that we could bring you all here today and talk about people-centered justice. As Scott mentioned, I spent a lot of my career at the Public Citizen Litigation Group, and one of our areas of focus was increasing the availability and affordability of legal services to ordinary Americans. We managed to do a lot in litigation. We struck down the minimum fee schedules. We opened up the ability of professionals to provide information, also known as advertising. We struck down many of the restrictions on admission to the bar in states that required residence requirements. I'm still finding time to keep on that track as I recently filed a petition with the Judicial Conference of the United States to enable lawyers who are admitted in one federal district court not to have to apply to all the rest of the 94 in the United States. I'm working with the American Bar Association, I'm pleased to say, to try to implement a policy which they adopted back in 1994 to reduce barriers to admission, which ultimately is going to be passed on to the consumers. But the one area in which I fail to make much progress is relates to the question of what people who are not lawyers are allowed to do, the unauthorized practice of law. We have been trying for years to provide additional services to individuals who need those services. We have been urging, and the Congress has finally come back to some extent, to give more money to the Legal Services Corporation to hire more lawyers. We have urged lawyers and law firms to engage in pro bono activities, and they have responded. But we have to be clear, and I know the ABA knows this, there are not enough lawyers around to be able to do this job. It will never happen, and we cannot continue to do the same thing as we've done before. So let me give you a couple of ideas today to go forward. Ideas that ought to work in the United States and ideas that ought to be guard against happening these kind of problems outside the United States. So the first thing I want to talk about is delegalization. When two people decide they want to get married today, they just enter an agreement and they get married, and an official, and today it's almost doesn't have to be any kind of official because almost anybody can solemnize the wedding. They enter the contract and they get married. So I ask, Well, if people decide they want to get divorced, and many, many people do in the United States, why do they need to have a judge approve their decision to undo the contract which they signed before? Now, of course, the state has an interest in seeing that many things are taken care of. But why can't we have a system in which people go down to an office? It could be the same office where they had the wedding. The state will present them with a list of things that they ought to think about. Have you taken care of the pensions? What about the car? Who owns the house? What about this and what about that? And if they've gone through the checklist and they've agreed, why is it that we have to have the judicial system and lawyers in many cases where we don't need them? Second, here in the District of Columbia, if a person dies, no matter how small their estate may be, they must go through probate. Why? What is the purpose of that? Why can't people go down to the court or the city hall and have someone walk them through what they need to do to be sure that the car is registered in the right name, the home is properly transferred? If everybody is in agreement, all of the heirs are in agreement, why should we need to have a big judicial proceeding? I am sure that there are many other areas of the law where if we thought about it, we would ask the question, why do we need legal proceedings? And we need to start thinking about that to get it down to a more manageable level. But the second and far more important matter is we need to find alternatives to lawyers. The definition of the unauthorized practice of law is too broad. If you read what the definition is, it essentially says what my friend and former ABA President Chesterfield Smith once told me: the practice of law is anything my clients will pay me to do. That's riding on an airplane, listening on a telephone, sitting in the courtroom, whatever I get paid for, that's by definition the practice of law. That cannot be the right answer, and of course, Chesterfield understood it was not the right answer. He was describing the world as it was, not as the world as it should be. We could take some lessons from our co-professionals in the medical world. I'll relay to you a small incident. I was out exercising, jogging a few weeks ago, and I tripped and fell and managed to cut my lip. So I went to the emergency room and I saw the nurse, and I finished seeing the nurse, and I said to him, when do I see the doctor? Oh, he says, you don't get to see the doctor. You get to see the physician's assistant. They're much better at this than the doctors are, and they do it all the time. And sure enough, they were absolutely right. Physician's assistants and nurse practitioners, they can prescribe medicine these days. So why do we have a system in the law where we have lawyers and everybody else, and people assist lawyers, but they can't do anything on their own without the lawyer there? I was at a program for the Legal Services Corporation about 2 months ago, and one of the speakers was Ron Flagg, who's the president of the Legal Services Corporation. And he explained something which I had not known, that the Legal Services Corporation is now encouraging their grantees to hire non-lawyers to do much of the work that was done by lawyers before. They've realized that economically it can't work the other way. Lawyers cost too much money. Legal education costs too much money. And then he said something at the end in response to what I used to hear from legal services lawyers. Well, if they don't have lawyers, these clients don't have lawyers, they're getting second-class justice. And Ron Flagg said 4 words. He said, as compared to what? As compared to no justice at all, no help at all. It seems to be that if you think about the question from that perspective, not from the perspective of what might a lawyer do, but what must a lawyer do, and think about the definition of unauthorized practice that way. One of my colleagues here at GW, Jessica Steinberg, and 3 of her co-authors, published a study in the March 2021 Fordham Law Review about an experiment that was going on in several jurisdictions involving efforts of judges to assure that victims of domestic violence were being helped in the way they needed to be helped in court. And nonprofit organizations have hired and trained individuals who have no legal education and not members of the bar to assist victims, claimed victims of domestic violence. And they have managed to do this in a way that the advisors help individuals get their cases ready to go to court. They do everything except appear in court on behalf of these individuals. And the judges are fully aware of this, and they are delighted because they were caught in situations where they cannot help these individuals, they cannot get the cases go forward, and cannot do justice. So the most interesting part of this study is that it's all secret. I won't say actually secret because there's a published law review, but the jurisdictions in which this takes place are not identified except by the names Plainville and Centerville as the two jurisdictions. And why is that? Well, the judges and everybody else understands that what these helpers are doing is technically violating the rules against unauthorized practice of law. That cannot be the right way to think about this. We've got to be able to find new and better ways in which we can see that people who are in need of services get the services that they need. Oh, let me suggest some ways about thinking about this. One is that the legal services organizations and of various kind, whether they're funded by the Legal Services Corporation or not, need to be able to start hiring large numbers of people who are not lawyers to do this kind of work. At the same time, bar associations, courts need to start thinking in the states and localities about redefining the practice of law so that people do not have to do what they're doing in Plainville and Centerville, which is hiding behind a facade that makes no sense. Now, is there a role for the federal government? I think the answer is yes. Of course, the federal government doesn't regulate lawyers, but they do two things that are very important. They regulate people who work before federal agencies. So, for example, I used to call it the Immigration and Naturalization Service. I don't know what the formal name of it now is, but people who want to have their asylum claims adjudicated or other claims, why can't they have people who are not lawyers who are adequately trained to provide the assistance that they need? And when they do that, the federal law for practice before federal agencies preempts what the states do, and the states cannot constitutionally interfere with that. So I urge that Legal Services Office do this, that there need to be independent nonprofit organizations that can provide the kind of services that we know are needed. I am not against licensing. I'm in favor of licensing where it needs to be. These individuals who are providing these services need to be trained. They need to be funded. But we need to be careful that what happened in the state of Washington does not get repeated throughout the United States, where a program, well-intentioned, had too many requirements, too many years of practice, too narrow a focus, and it ended up going out of business because there was simply no demand for the amount of money that had to be spent going forward with that. The last suggestion I want to make is, again, as compared to what my law students here are dying to do pro bono work. They're dying to go down to the courthouse and actually talk to people that they can help in the landlord-tenant, the collection divisions, but they can't do it now. We have wonderful clinics here at GW, and there are at all other law schools, but the clinics are different. The clinics are there to teach individuals how to become lawyers by dealing with clients. They are not instruments of mass justice, and that's what we need to have. So I'm urging that all of these actions need to be done. We need to rethink the definition of unauthorized practice of the law in terms of the realities. And I hope that this conference will be a step forward to that. And as we promote the rule of law abroad, we need to promote it here in the United States as well. Thank you very much.
Thank you so much, Associate Dean Morrison. So next up is someone who really needs very little introduction, I will say. Suffice it to say that after graduating from Stanford, Oxford, and Harvard, Justice Breyer embarked on a most distinguished legal career. From special prosecutor in the Watergate matter to Senate counsel, and then to justice on the Supreme Court of the United States. And along the way, he's found time to teach at his alma mater and publish widely. And last but not least, he has graciously agreed to chair our board at the Rule of Law Initiative. And he's currently taking a call. Please help me welcome Justice Breyer.
Good. I'm glad you're having this conference. And I'll just give you 4 examples of something. 2 macrocosm, which you'll all say yes, yes, yes. But you can't do too much about that. We all can do something about it. Called what is the rule of law? See, I talked to students about that. There was a good conference on this in Belgium, I think, at one point. And they said, well, it's the opposite of the tyranny and so forth. It's the opposite of just anarchy it's what King John was doing, and then the barons went out and made him sign a piece of paper that Magna Carta said they wouldn't do it anymore. All right, do we have anything to do with that? Of course we do. A woman who is Chief Justice of Ghana was in my office a few years ago, and she said, why do people do what you say? And I have to explain to her that I don't know totally the answer there. When the Cherokees were given the land by the Supreme Court in northern Georgia, because of course it belonged to them, the President of the United States, Jackson, sent the troops to kick them out. Well, why doesn't that still happen? It took a long thing. We had a civil war, we had slavery, we had Reconstruction, we had all kinds of stuff in this country. But gradually we've got there, so when I hear Senator Reid say a remarkable thing about Bush v. Gore, I dissented, but which I tell this is never remarked, that despite the fact that people think it's wrong, a lot of people think it's wrong. I say half the people think it was wrong, maybe a few more than half, but regardless, they followed it. No guns, no throwing things, no stones thrown. And I'm talking at Stanford, I say, I know about 30% of you, minimum in this audience, they're students, think too bad there weren't a few riots. And I say, before you make up your mind about that, go turn on the television set, and see what happens when you solve your problems that way. And so that makes a point. That's a general point. And a good book I tell them to read is Camus, The Plague. At the end of The Plague, he says, that plague germ, really the Nazis. That plague germ is in every human being. It never dies. It goes into remission. And it comes out of remission. It's been lurking in the file cabinets. It's been lurking in the hallways. It's been lurking in the attics. And it'll come, and it'll send its rats again into a once happy city. I say that's generally, I'm saying to the students or to the foreign professors, whoever I'm talking to. That's why we're in this, together. We're in it to try to make a difference. But we all start there. That's just to remind us that there is some importance to what we're doing. And I think that what we're doing, it's interesting to me. Why? Because of 2 experiences, I can think of 3 or 4. But I love it. What is it? It is that people have problems. And we're trying to help them. So I think when I went into the courthouse on the Strand, that's a beautifully designed courthouse, in the late 19th century, the British courts. And the first thing you see when you go into that courthouse is there is a big booth, and there are people who are not lawyers. And what are they there for? They are there because people walk into that courtroom who have problems. And you walk up to that booth and they say, what's your problem? And the person will say, this is my problem, and the person behind the desk, either herself or maybe finding somebody, will say, this is what you do, phone this phone number. This is the Social Security Administration. Or this is what you do. You phone this person over here, and they will help you with your house, or whatever it is. And maybe you'll go to a lawyer, and maybe not. But the problem is the person. And the person has a problem. And so we figure out ways of helping efficiently and effectively solving the problem. I saw the same thing in India, where Sandra and I went, as O'Connor and I were over there, and oh God, it was a problem. There were a few problems. But there in Ahmedabad, one of the judges takes us to looked to me, I'm from California, and it looked to me like one of these houses in Monterey, a beautiful house, wooden, standing on stilts, with a big porch here, here, here. And on that porch, all the way around, was a queue of women. And this queue of women stretched back from the porch all the way up the top of the hill. So I said, what's that? He says, well, we have in this house, he says, in this building, we have 4 rooms, and in each of those rooms there are 3 women, and the 3 women, one is a social worker, one is a psychologist, and one is a lawyer. And that queue of people are women who are from villages nearby, or maybe the city, but they have a problem. And they're going in there, and the question that the 3 are trying to deal with the woman is, what's your problem? And what's he going to take? Is it that your in-laws are stealing your dowry? Is it your husband is beating you up? I mean, what is it? And they have people who have the connections there so that this human being can get her problem solved. Maybe, we hope. Now, that isn't always true in India or any other place. Sometimes they just say, go to the police. Why? I mean, maybe, and maybe not. And the question is, well, what is the problem? Now, I've got a big picture of this building. This is at the right time. I put it in my office just behind it. And when I have sometimes some of the people from the women's groups come in, are there for a variety of reasons. And somebody will notice that and they'll say, what's that? And I say just what I said. And then I add, of course, we have groups like this, don't we? I know perfectly well we don't. All right? And so there we are. Now, what's going on here, it seems to me the same thing is going on. I'll be in Greece next week and I talk to a similar group. What's going on here is how can we figure out the ways in which human beings do have problems, and they might be problems that law has something to do with, but the solution might not be legal, or it might be. But we're going to try to set up institutions that do better with those problems, or that are cheaper, or that are more expensive, but they do better, or that, or that, or that. Now, who can figure that out? Me? No, I can't figure it out. Who can figure that out? You can figure it out. So we're spending a day sort of saying, yeah, what I'm doing here is here, that's good, it's helping the people, and it's related to this thing up here, which is the rule of law in general, which works if and only if people in a country will say sometimes, I'll follow these rules, judges' rules or other rules, and I'll do it even if I don't like it. It's so easy to have a rule of law when what's being decided under the law, and you have to follow are things you like. Not so easy when you don't like them. That's what I heard Harry Reid say. He said, after all, Bush v. Gore was what he was talking about. Important? Yeah. Affects people? Yeah. Do they like it? The ones I'm thinking of? No. And by the way, it might be wrong. I thought it was wrong. I mean, 5-4, somebody's wrong. Okay? But until you have people adjust to this, and you'll only do it through the microcosms that you're working on, you don't have a rule of law. So the poor woman from Ghana had to listen to all this. But she apparently liked it and interesting, and now you're spending a day on it, and I think that's just great. Thank you.
Thank you so much, Justice Breyer. So our next speaker is Elizabeth Betsy Andersen, who is currently the executive director of the World Justice Project. And that's a leading group looking at how to advance the rule of law through research, strategic convenings, and support for innovative programs. I should also say she formerly held my current position, and she left big shoes to fill. Betsy's a member of the Council of Foreign Relations and serves as a member of the Board of Trustees of Williams College. And and she's, that's in addition to her alma maters of Princeton and Yale. Betsy has held multiple clerkships, including one with an old professor of mine, Judge George Abisad of the ICTY. Please help me welcome Betsy Andersen.
Thank you, Scott, and it's a pleasure to be here for this important conference today, tackling the global challenge that we have in meeting access to justice for all. I think my role here in these introductory remarks is to contribute some data to the conversation, data about justice gaps and data that point to some of the solutions before us. But let me begin my remarks with a story. It's a story of Louisa. She's an immigrant to the United States and has temporary protected status and work authorization. But a glitch in the USCIS computer system meant that she did not receive the electronic certification of the extension of her work authorization. She works as a housekeeper, and her employer said, "No worries that you don't have that proof of work authorization." He would rather not report her employment and pay the related taxes in any event. So he told her, "No worries, I'll pay you under the table in cash." Walking home from the metro one day, her purse was snatched and she lost 2 weeks of those cash wages. When she was subsequently unable to pay her rent, she was evicted, notwithstanding a moratorium on evictions in the jurisdiction where she lives due to the pandemic. There were notices about the moratorium in the metro, but most of them were in English, and so escaped her understanding since she has very little English language skills. Besides, Louisa can't afford to take time off from work to seek legal assistance and go to court to fight the eviction. Louisa's story is fictitious, but it's based on real circumstances and draws on data from real cases. It shows how people experience justice problems and the justice system. It's illustrative of millions, even billions, of people's experience with the justice system the world over. According to a 2019 study by the World Justice Project, where we were aiming to measure the global justice gap, 2.1 billion people are employed in the informal sector, like Louisa. 1.1 billion are victims of nonviolent crimes such as burglary and theft annually. 2.3 billion lack proof of secure housing and land tenure rights. And 1.4 billion have unmet civil or administrative justice needs. Many of these circumstances are overlapping and compounded disproportionately in poor and marginalized populations. We're here today to explore a reorientation of our justice policymaking in order to take as a point of departure the experience of people like Louisa. For far too long and in too many jurisdictions, we have approached justice system strengthening from the perspective of institutions. We have asked, what do judges and lawyers and prosecutors and bar associations need to do their jobs better, without fully understanding the needs of the people those institutions are intended to serve. By contrast, a people-centered justice approach flips that strategy on its head. It begins with mapping people's justice needs, the ways in which they solve their justice problems or fail to do so, and the obstacles they face. Armed with this understanding of what has been referred to as people's justice journeys, we can design justice institutions and policy interventions to meet people's needs more effectively. So what difference does this shift to people-centered justice mean for our policymaking? A big difference. The World Justice Project has undertaken legal needs surveys in 101 countries, gathering data from over 100,000 households. It's the largest data set of this nature available and there are copies out on the table there if you're interested, also on our website. This exercise to map people's justice journeys across the globe is very revealing. We found that justice problems are ubiquitous and frequent. Globally, approximately half, 49% of us who were surveyed in these representative samples had at least one legal problem in the past 2 years. In the United States, the number is higher, 66%. Most people do not turn to lawyers and courts. Less than a third of people who experience a legal problem sought any help at all, and most prefer to turn to a family member or a friend. Just 17% took their problem to an authority or third party, a lawyer or a judge, to mediate and solve the problem. Finally, people face a variety of obstacles to meeting their justice needs, beginning with their ability to even recognize their problem as legal. Our research showed that fewer than 1 in 3 understood their problem to be legal, as opposed to just bad luck. Most people do not know that the law and lawyers and courts afford them solutions, that they have rights. In other cases, we found that people knew they had a legal problem, but faced other barriers. 1 in 6 reported that it was difficult or nearly impossible to afford the services they needed to solve their problem. Again, in the United States, this is even worse. In our data set for the Rule of Law Index, the US ranks 116th out of 140 in accessibility and affordability of the civil justice system. Justice policy that takes on board this data about people's justice journeys looks very different. Rather than reinforcing institutions to which people do not turn, a people-centered justice policy focuses on understanding people's needs and transforming justice institutions and services to meet those needs. Let me just mention 4 ways in which this changes justice policy. First, a people-centered justice system will emphasize a strengthened data ecosystem to capture through legal needs surveys and administrative data a clear picture of people's justice needs and experiences. Imagine a healthcare system. I should say, don't tell the doctors, but we have a little bit of healthcare system envy here among us lawyers. Imagine a healthcare system where we did not know the prevalence of illnesses we were trying to prevent or treat. That's where we are in terms of data in our justice systems in most jurisdictions. A people-centered approach will also employ preventive strategies to address the root causes of prevalent justice problems. Again, imagine a public health system where we poured money into hospitals but ignored vaccines. A people-centered approach will also emphasize information and education about legal rights and remedies so that people can come to understand the justice services available to them. And finally, a people-centered approach will focus on removing barriers to the assistance that people need, issues relating to language, the physical location and cost of services, as well as excessive regulatory restrictions on the provision of basic legal services, as the Dean made the case for very powerfully. It will take advantage of cross-sectoral collaboration, fostering partnership between the justice system and the education system and the health system and other social services to meet people with the justice services they need where they are. Taking a people-centered approach to justice requires a major change in the way we do justice system strengthening here at home and around the world. The good news is that as this conference evidences, that shift is well underway. USAID has put people-centered justice at the heart of its new rule of law policy, while the Department of Justice is stimulating important innovation and reform here at home with the committed and creative leadership of its director, Rachel Rossi, whom you'll hear from momentarily, as well as the Attorney General. 19 governments, including the United States, and a couple dozen civil society and international organizations have formed the Justice Action Coalition to drive this agenda forward. And the American Bar Association, serving as the national voice of the legal profession here in the United States, as well as promoting the rule of law around the world, is uniquely positioned to champion this cause. I commend you for convening this important discussion today and look forward to a rich exchange about how we can pivot to people-centered justice. Thank you.
Thank you, Betsy, for that sobering look at the data or the lack thereof. That's a big part of the whole idea behind people-centered justice, right? It's that it's data-driven. And if you got data gaps, the first thing is collecting the data. And WJP has been instrumental in pushing this, and we're thankful for that. So next up is Director of the Office for Access to Justice, Ms. Rachel Rossi. She was appointed by President Biden and Attorney General Merrick Garland in May 2022. And I think a lot of us in the know were so happy when we heard that news, because that particular office had not enjoyed a lot of attention in some recent years past. Director Rossi comes to that position eminently qualified. She has a distinguished career as a public defender in Southern California, where she vigorously defended literally hundreds of low-income clients in both state and federal courts. But it gets better. Recently, Director Rossi served as counsel to the Senate Judiciary Committee under the chair, Richard Durbin of Illinois, and she was the lead staffer on the First Step Act, a major U.S. federal criminal justice reform bill that was signed into law in 2018 that created comprehensive sentencing reform and prison reform. Director Rossi is a graduate of Pepperdine University, and like many of us here, enjoys a rich immigrant background from the Dominican Republic and Greece. Please help me welcome Director Rossi.
Good morning. Thank you so much, Scott, for that kind introduction. And just want to express deep gratitude for the ABA's Rule of Law Initiative, for your ongoing partnership, and for hosting this really impactful event. A huge thank you to the event organizers, David, Sarah, and Lorraine, for your hard work in planning this discussion and organizing so many powerful people in one room today. It really is also a distinct honor and privilege to speak at this event with Justice Breyer, a longtime leader on access to justice throughout his distinguished career, and of course, Associate Dean Morrison, Judge McCown, and of course, Betsy. The World Justice Project is an esteemed partner. We value your reports, research, and of course, the Rule of Law Index, which we regularly review, and the data that you mentioned is very sobering today about the U.S. ranking. We know that we have much work to be done. It is also an honor to join all of you here today who have dedicated your work to increasing access to justice for people across our country and around the world. In particular, I want to recognize the many civil society leaders who are here with us today, including a representative from Ukraine Center for Civil Liberties, who continue a very inspirational fight for accountability and human rights. So I was so pleased to see that the theme of this conference today included focusing on advancing people-centered justice at home and abroad. Sometimes many of us can become siloed into our own contexts, not realizing that another city, county, state, or country or organization has learned and adapted to certain challenges that we are also facing. This event is a testament to the importance of shared learning, resulting in stronger foundations, responses, and outcomes for all. And it highlights the most important why of all, the reason for government, for rule of law, and the reason that we fight for strong democracy, the people. The Department of Justice's Office for Access to Justice is working to advance a people-centered approach across our work. And today I'd like to share how this focus serves to expand, strengthen democracies and rule of law, both at home and abroad. As you may know, and as Scott mentioned, in October of 2021, Attorney General Garland reestablished the Office for Access to Justice to ensure that we are making the promise of equal justice real for everyone. He asked our office to lead a whole-of-government approach to expanding and modernizing the department's access to justice function and to work to close justice gaps in both criminal and civil legal systems. We have been proud to see that this mission of access to justice is among Attorney General Garland's highest priorities. The Office for Access to Justice works to ensure that all communities have access to the promises and protections of our legal systems and government, that justice does not depend upon your income, age, gender, status, identity, ability, or the language that you speak. Our office also collaborates on the pursuit of access to justice before international organizations, including the United Nations and the Organization for Economic Cooperation and Development. We also lead the US government's efforts to implement UN Sustainable Goal 16 on promoting peaceful and inclusive societies, ensuring equal access to justice for all, and building transparent institutions. And as we pursue our work, our mission is guided by three broad principles. First, increasing access. We work to break down the barriers to accessing legal systems by expanding availability of legal assistance and other legal help and supporting public defense. We're also committed to eliminating barriers that exclude people based on economic status, race, identity, language, or disability. Our second principle is accelerating innovation. We use research, data, and innovative strategies to improve fairness and efficiency in legal systems and to promote modern, evidence-based practices to further equal access to justice. And third, safeguarding integrity. We promote accountability and the integrity of our legal systems through criminal and civil justice system reform. When pursuing equal access to justice for all, we know that it is important to expand access to the systems as they exist, but it's also important to promote reform of the systems themselves to root out systemic inequities. So we believe that justice should belong to everyone. And at the core of this mission and this very lofty goal is a need to understand where the access gaps are, who is not at the table, and what barriers communities are facing to the promises of justice. So we're building a strong and innovative team at the Office for Access to Justice with a people-centered approach at the center of our work. Last summer, I was honored to be appointed as director, and since then, our team now consists of 32 highly motivated professionals who I work alongside with every day toward building and accomplishing this mission. Today, I'd like to point out that I am joined by two colleagues, including Jesse Bernstein, please wave Jesse, who serves as our senior advisor for international issues, and Lauren Lambert, our public affairs lead. Jesse plays a primary role in collaborating with our international partners and building our portfolio as we look at our mandates that are international facing, and he looks forward to engaging with many of you. So I hope you'll reach out to him and see him as a resource. So what is people-centered approach, a people-centered approach to access to justice for our office? It first starts with humility and an acknowledgement that structural inequities exist. Indeed, our legal systems have failed too many people and have not delivered on their promises and protections for all. And it requires us to consistently center the voices of the people we serve, particularly the voices of historically underserved and marginalized communities, to develop the solutions that close these justice gaps. For example, the Office for Access to Justice hired the first ever department-wide language access coordinator. According to the US Census, the number of people in the US who spoke a language other than English at home has nearly tripled since 1980, from 1 in 10 people to 1 in 5 people. Linguistically marginalized communities and those with limited English proficiency, including those who are deaf or hard of hearing, cannot be precluded from reporting a crime, understanding their rights, or navigating a court process because of the language they speak. The Language Access Coordinator has a department-wide mandate, but sits in the Office for Access to Justice. We've now relaunched the Department of Justice Language Access Working Group, chaired by the Language Access Coordinator. And through that working group, we have representatives from different components across the Justice Department working to expand language access across all of our work. Right now, through the working group, we're updating and modernizing the department's language access plan pursuant to the November Attorney General Garland memo on strengthening the federal government's commitment to language access. And we started that process with stakeholder engagement with the communities who try to access the Department of Justice and may not speak English as their primary language. The language access team is also working on efforts to centralize and expand language access resources and to provide training and technical assistance to other offices within DOJ. As our language access work grows, we hope to serve as a national model and a collaborator with our state and local partners in this shared goal of language justice. Our office also prioritized people-centered approaches in our work through the White House Legal Aid Interagency Roundtable. We direct and staff the Roundtable. It's a collaboration of 28 federal agencies that is co-chaired by Attorney General Garland and White House Counsel Stuart Dellery. And our office houses the executive director of the Roundtable, and we are mandated to staff the Roundtable. In 2022, the Roundtable issued a report focused on simplifying government. Specifically, we looked at how to simplify forms, process, and language so that the people can more easily access federal resources. Most importantly, as we developed the approach for simplification, we created a roadmap to simplifying access that starts with understanding the community's experience, understanding barriers that people face when they try to access government, and then using that feedback to directly inform solutions to simplify access. And most recently, the Department of Justice celebrated 60 years since the US Supreme Court decision recognizing the right to counsel in criminal cases, Gideon versus Wainwright. And to do that, I know some of you were here, to do that, we launched a countrywide tour to hear from those on the ground doing the work of making that Sixth Amendment right a reality. High-level Justice Department officials joined me, including the Deputy Attorney General, the Associate Attorney General, the head of the Criminal Division, and the head of the Office of Justice Programs. And we visited with public defenders, impacted communities, and advocates across the United States, from urban cities to southern, Midwestern, tribal, and rural areas. We heard directly from the people doing the work about the barriers to ensuring effective access to legal aid, and we announced a number of specific actions in response. And we're looking forward to issuing a publication that highlights all of this work later this year. So what we've learned is that when we trust the experiences of the communities we serve, solicit their ideas, and carefully tailor responsive strategies, we can form honest and empowering partnerships and invest together in lasting solutions. This type of engagement builds trust in government, confidence in the rule of law, and more resilient democratic governance. The Office for Access to Justice shares our approach, lessons, and best practices with counterparts around the world to inspire change. But we also prioritize listening and learning from our global partners. Our approach is grounded in humility and mutual respect, given the serious challenges that numerous communities are facing here in the US in accessing justice. One way that our office pursues these goals is through participation in global coalitions, forums, and bodies. Last September, I was pleased to join the OECD Access to Justice Roundtable in Riga, Latvia, where I participated in a panel on interagency and intergovernmental approaches, and we highlighted the work of the Legal Aid Interagency Roundtable. At the Summit for Democracy in March, I was also pleased to participate in a side event with USAID, focused on the rule of law and people-centered justice. And I was also pleased to support the US finally joining the Justice Action Coalition, which serves to share information and resources on implementation of UN Sustainable Goal 16. And I know we have Swati from Pathfinders here in the audience with us. Thank you for your work and of course for the Netherlands, for your leadership as we look forward to participating in this coalition. Next week, I'm also looking forward to participating in the UN Commission on Crime Prevention and Criminal Justice in Vienna, where the official theme is access to justice. And we are excited to highlight our access to justice work and to learn from others. We also look forward to taking part in negotiations on a Canada-drafted first ever resolution on access to justice. The Commission is expected and hoping to pass that by the end of its session. And finally, last month, Attorney General Garland led the department's participation in the annual Cross-Border Crime Forum with Canada, which this year took place in Ottawa, and I was pleased to participate in. Alongside the forum, I had formal meetings with Justice Canada's Access to Justice Secretariat. Canada is, we believe, the only other government to have an Office for Access to Justice, and it was modeled after our Access to Justice Office. Canadian representatives shared information about their access to justice efforts as part of public safety strategies, including to reduce mandatory minimum sentencing, to reform bail practices, to pursue recidivism reduction strategies, and to expand post-conviction integrity efforts. Canadian leaders also highlighted their official Black and Indigenous justice strategies, which aim to address overrepresentation of these groups in Canada's criminal justice system, and which include specifically formal roles for those impacted communities to participate in the development and implementation of these strategies. We also learned about Canada's use of data and people-centered justice approaches and met with Canada's Action Committee on Access to Justice in Civil and Family Law Matters to learn how Canada engages with a cross-section of civil society and official representatives to advance access to justice in civil courts. At the conclusion of the Cross-Border Crime Forum, ministers from both countries noted that, quote, importance of continuing our work regarding groups already overrepresented in the criminal justice system is important to guard against reversing the strong progress made on this front. These types of engagement with global partners are important as we continue to pursue access to justice here at home. As the exacerbation of the longstanding access to justice gaps have only been exacerbated and expanded through the COVID-19 pandemic and continue to face our country, elevating our domestic strategies and engaging with global partners to develop solutions is ever more critical. This is why our approach includes learning from other countries to strengthen our own response to access to justice here. So to conclude, very simply put, access to justice means people-centered justice. And recognizing the importance of the Supreme Court decision in Gideon versus Wainwright, Attorney General Merrick Garland stated that the decision, quote, reaffirmed that the law protects all of us, the poor as well as the rich, the powerless as well as the powerful. In doing so, it reaffirmed this country's commitment to the rule of law, and trust for the rule of law is what holds American democracy together. People-centered justice is central to developing that trust. This is why the work that all of you and us in this room are pursuing is so important. Work to expand data, transparency, innovation, and to promote access to justice strategies for all can bridge those trust gaps between marginalized communities and officials and government. It can serve as a tool to elevate the voices of the communities most frequently unheard, but most often in need of the protections of our laws. And to ensure that their communities, that the voices of the communities we serve are at the forefront of informing solutions. Most importantly, people-centered justice can serve as a way to promote accountability of our legal systems and to root out systemic inequities which undermine progress here at home and abroad. So thank you so much for your commitment and service toward these ideals. We know that this is only the beginning for our office and for our work, and I look forward to continued collaboration and engagement. Thank you.
Director Rossi, you have obviously been very busy recently. And let me just thank you so much and the Department of Justice for sharing you with us today. It's delightful to hear the progress you've made, and we look forward to future progress. Thank you. So our next speaker is Judge Margaret McEwen, who was appointed to the United States Court of Appeals for the Ninth Circuit by then President Clinton, and was confirmed by the Senate in 1998. She's a graduate of the University of Wyoming and Georgetown Law, And like Justice Breyer, we're very happy to have her in a senior position on the ROLI Board of Directors. Judge McEwen has been very active in a wide variety of fields. Just to give you a flavor, she was recently president of the Federal Judges Association. She's had stints on the Council of the American Law Institute and on the Executive Council of the American Society of International Law. But despite doing all those things, she still finds time from time to do pro bono work for ROLI, and she most recently returned from Colombia, and perhaps she'll even tell us a little bit about that. Please help me welcome Judge McEwen.
Well, thank you. It's a pleasure to be here. And my topic this morning is the future of democracy and the rule of law. So appropriately following the comments by Ms. Rossi and others. You know, all you have to do is pick up the paper and see all the headlines about the decline in democracy and the coming crisis. And it's not all contrived, of course. Democracy has been in decline around the world for at least the past decade. And those of you here, including me, have actually witnessed it as you've been out in the field. But I think it's important to figure out how to cut through all these histrionics of the news reports and make sense of what's actually happening out there. But a common and very legitimate theme is the decline of the rule of law. And of course, that's an issue particularly close to my heart. Rule of law, it's written all over our papers today, and you'll see it in your material. So what is it? It's a lofty concept. It sounds fantastic, but sometimes we don't really sit back and say, well, what does it mean? It's not just this catchy, feel-good phrase that we have, but, it's really the foundation of our democracy. And I think it's both the spirit and also the reality of a transparent and accessible system. The rule of law represents who we are and our values: democracy, tolerance, fairness, and freedom. Now, it's no surprise there's no uniform definition of rule of law, and it was actually conceived back in the 19th century by a British legal scholar. But importantly, what I think we emphasize now is rule of law does not mean rule by law, because there's a big difference. And maybe one of the good contemporary examples might be Russia. Some people think Russia has a beautiful constitution as written, and you can look in there and you see quite a delicate balance in the separation of powers. Perhaps the reality is quite different because there is a lack of a culture of law. But one of my most favorite is to recognize that nobody has a monopoly on touting or invoking rule of law. So I recently ran across a manifesto published by Xi Jinping, the president of China. And here's the title of it: Xi Jinping Thought on Rule of Law. So it's often weaponized, of course, and used to undermine the justice system. When I think about where are we in the contemporary rule of law, I think it helps to kind of go back in time and think about, well, where have we come from? And how have we developed in contemporary times this concept of rule of law? Go back to post-World War II. We had a sense of confidence and optimism as democracy was expanding across the globe, and it seemed that it was without limit. Of course, there was the Nuremberg trials, and that was really seen as a watershed event in international law, and also the vindication of human rights. But of course, that advent of this incredible feeling of euphoria was shattered with the Cold War, and for almost 44 years, Russia and the United States were facing off. Then we had the fall of the Berlin Wall, 1989, and the aftermath. And so what did we see in the 1990s? Well, peaceful revolution, overthrew most of the governments of the Eastern Bloc, and now there's this new giddiness and euphoria again, and the promises of liberal democracy. But what we learned is that this decommunization did not lead inexorably to democracy. So there were a number of liberal democracies that expanded, of course, but some countries became failed states, or they were seized by authoritarian regimes. So now here we are in the 21st century, and we're rife with new challenge. What's the state of the rule of law today? Well, I wish I could deliver you a report card that would make every mother happy, but I don't think that will be the case. There's a recent book out by Paul Stefan, a scholar at the University of Virginia School of Law, and he wrote that the 21st century became the place where hopes of the 1990s went to die. Well, that's a pretty doom and gloom, and I have to say, I think we are in the middle of a rule of law recession. It's characterized by closing space for media and civil society, declining trust in institutions, and this prevalence of authoritarian governance. As Betsy has offered up some of the data, important data by the World Justice Project, 4.4 billion people live in countries where the rule of law is declining. So the reality of this landscape, I don't think, should lead us just to a room of people here and on the web of doom and gloom, but it's really a challenge to redouble our efforts and to embrace this new paradigm of people-centered justice. I look ahead and I say, well, what are the challenges? They're endless. Migration, discrimination, climate change, nuclear war, poverty, plague, famines, pandemics, and more. So I just want to focus on two areas that are of particular interest to me and I think play out in the rule of law. One is the heavy hand of the executive on the judicial branch. And second is the double-edged sword of the internet. They're not unrelated. So as the executive and executive branches seek to impose more control over the judiciary and curb the independence of the judiciary around the world, at the same time they're cracking down on internet freedom, which is a direct crackdown on their citizens. Now, I want to turn to this heavy hand of the executive. A recent soundbite that we often hear is that the rise of authoritarian governments has led to the fissures in a rule of law, whereas democratic regimes uphold the law. However, I think it's a mistake to rely on this argument and this dichotomy of just authoritarianism versus democracy. And why? Because we've seen both democratic and authoritarian regimes that invade the separation of powers. And along with legislatures, they place a heavy hand on the rights of the citizens and also the judicial power. So I want to offer a few examples of what I would say is putting the government's fist on judicial independence. We often hear about thumb on the scale. I think it's a fist. I think it's really disingenuous and an understatement to say it's a thumb. So I want to give you a few examples, and I'm going to start with one that I hadn't anticipated, and it plays off at Justice Breyer. So some years ago, I was asked by the State Department to go to Venezuela. They had ousted members of the Supreme Court. They were spurning U.S. diplomats, and the relations were terrible. As I headed down to Venezuela, our government had called Hugo Chavez the crackpot from Caracas. So it was hardly really a great environment for a United States judge to go down to Venezuela and talk about the rule of law. They asked would I be on a radio program, and I said sure, because usually that entails some softball questions, which I can reasonably answer in my Spanish. So I get down there and I answer the softball questions, and the guy says, and this is a call-in radio show. And I'm like, call-in radio show. First question, Bush v. Gore. How can you say that you uphold the rule of law when the United States Supreme Court issued Bush v. Gore? Now, I was not prepared for that question, of course, but remarkably, I actually gave almost exactly the same answer that you just heard from Justice Breyer. So I must have been channeling him at the time unknowingly. But I said, not everybody agreed with Bush v. Gore, but at the conclusion of that, as like the conclusion of many of our Supreme Court cases, which we may or may not agree with, our citizens went back to work, and everybody, put on their clothes. They went back to school. We swore in the president, and life went on. Now, I have to admit, if I were down there today and they asked me that question, I would have to bring up January 6th. And I'd have to say we might have to re-examine some of these issues domestically. But that's really not what I'm here to talk about, but I just couldn't help but relay my example in Venezuela after hearing from Justice Breyer. Let me give you a couple of other examples. Everybody here is quite familiar with these across the world. Tunisia, for a number of years, Sealy ran programs in Tunisia. I had the privilege of going down several times, and it was really this emerging and bright spot democracy. Now, 10 years later, the Brookings Institution calls the democracy a work in progress. And why? Well, the democratically elected president basically intends to dissolve the High Judicial Council, and he actually closed the Supreme Court building so the justices couldn't even do their job. Then he dismissed a large number of judges, and despite a court order, he refused to reinstate them. So Tunisia, which we once thought is this lone bright spot in the Arab Spring, now suffers from this heavy hand of the executive. Move to the Far East, Hong Kong. So we know that the democracy advocates are flexing their muscle in Hong Kong, but at the same time, Beijing just issued this very unusual interpretation of their national security law. And what did it do? Well, it gave the chief executive power to overturn court decisions. It also banned foreign lawyers in certain respects, and the chief executive could even choose judges for trial. We're now faced with a situation where a large number of pro-democracy advocates are on trial, as we are here. The trial's been ongoing. What's their crime? Conspiracy to commit subversion. And what did they do? Well, they participated in an unofficial primary election, something that we might think of as the very essence of democracy. But true to form, the government touted, quote, Hong Kong prides itself on the rule of law. So sadly, this irony illustrates this difference between rule of law and rule by law. Poland also views itself as a democracy and has been incredibly generous in its treatment of refugees from Ukraine. But under the guise of addressing corruption, they passed laws that basically bring the judiciary under political control. So it is an amazing sight to see the photos of the judiciary in Poland actually in the streets protesting what had happened to them and their colleagues. But of course, Poland's not alone in Europe. Go across the border to Hungary, it's no better. And we also see similar concerns in other parts of Europe, the Czech Republic, Latvia, Malta. Guatemala, it's shifted from what has been labeled a democracy to a kleptocracy. And so what's happening down there? Well, you've read about the incredible unrest. You've read about the Civil War. You've read about the peace process. But now the president has jailed anti-corruption judges. And there's a particular court called the Court for High-Risk Crimes. That court hears the most sensitive issues relating to criminal law and to corruption. But those judges have been physically intimidated, and they've been threatened with their loss of judicial immunity. So what happened? At least 22 of them and more since 2022 have fled the country or gone into exile. Guatemala ranks 110th of 140 countries in the World Justice Project Index. So I don't want to leave these examples because I could go on, and you can think of many more, but I have to touch on Israel. Because in January 2023, the Justice Minister announced all these reforms would overhaul the judiciary and the power of the Israeli Supreme Court, which had long been regarded in the United States and abroad as really an example of judicial independence. But now they're going to have the ability to override decisions and to reconfigure the appointment power. Well, we know everything has come to a halt. Critics agree this would be a fatal blow to judicial independence. So following these mass protests, the plan's on hold and stand by. Maybe next year when we come back, we'll have something else to report. So at the same time that we're seeing this incredible executive power handicap institutions, we've also seen another aspect, and that is the government control of the internet. It's only exacerbated the situation. So think back in time. Mid-1990s, as really the United States was the only country connected at that time to what we now know as the internet. There were 18 million people. We now have 4.5 billion users on the internet. So it is a very powerful forum. And like a lot of technologies, when the internet, came about, it was really celebrated. It was transformational, no doubt about it. It would be a democratization tool. It would actually be a way of community networking, a political movement in its own right, and on the global scale, the thought was we now have a foundation worldwide for citizens to join the global democracy agenda. But like many things, even going back to the telegraph, the very properties that made the internet such a global phenomenon also had a lot of downsides and put them in the hands of a repressive government or authoritarian regimes. And governments have now become as adept as activists at harnessing this power of the internet. As far as internet freedom, Freedom House has undertaken studies for a number of years, and for the 12th consecutive year, freedom on the internet has declined worldwide. So digital repression has followed other forms of political repression and also crackdown on human rights. China is tagged as the most repressive online environment. And how do we see it? Well, censoring access, targeting journalists, activists, religious groups, and minorities, and of course, very harsh regulation of technology companies. Situation in Russia is no different. Just last year, Russia blocked access to Facebook and Twitter and new uploads on TikTok. The war in Ukraine has really just exacerbated the situation. And I think of the circumstance of a young university student who made an online post about the war. She was quickly arrested. And why? For justifying terrorism and discrediting Russia's military. She was put on house arrest with an electronic monitor. She looked to the future and realized that her future would be in prison. So now we had this very aspiring young activist university student, and she's fled to begin a whole new life in Lithuania. But I would say that she's just one vignette of the human consequences of internet repression. So what does it mean for the rule of law? Well, nothing good, as you might imagine. When you go to countries around the world, we look at their constitution, we also look at their various laws. Free speech is prominent. But the crackdown on free expression on the internet has really proceeded in defiance of all these written laws, the so-called rule by law. So what we thought would come from the internet, transparency and accountability, and it should have heightened really the digital world and the access, has really become at grave risk. I want to point to just one of the most troubling developments in the internet world, and that's criminalization of the internet. On this, I'm not crying wolf. There is these specific laws now, not just general speech laws, but targeted at the internet, and they impose incredible sanctions for saying anything against the government or even spreading alleged misinformation, whatever that is. What happens? Citizens have landed in jail with long sentences. So just in the past few years, governments in 56 countries have seen people either investigated, arrested, or convicted. So I went back and thought, well, okay, I'll just look for last year, look for a few examples from last year. Last year, Turkey passed a law that gives you a jail sentence up to 3 years for spreading misinformation. In Myanmar, a pro-democracy activist was executed after he had condemned online the military coup. And in Rwanda, an activist netted 15 years in prison for putting up a YouTube video for criticizing the repressive president. So here we are at this conference to consider where we go from here. And although this moniker of people-centered justice is of more recent origin, I don't think the concept is new in many respects. So ABA ROLI has undertaken projects, programs on people-centered needs for years. So it's no surprise that ABA ROLI has jumped into the internet arena, and we have programs on internet freedom, particularly those in Eastern Europe and Southeast Asia, training advocates on how to counter internet repression. As Scott mentioned, I was recently in Colombia, and we're working there with indigenous populations on access to justice. And importantly, we know access to justice doesn't mean courts and lawyers. We're talking about informal justice as well as formal justice. And then we have, of course, programs in 55 countries across the world. So where does that leave us? Well, I have no panacea, of course, in getting the rule of law back on track, but I do have a few observations to leave you with. The first of these is that the rule of law cannot be delinked from the economy or the private sector. It's not the exclusive domain of governments or of non-governmental organizations. And in the internet arena, we have to consider that there's incredibly complicated trade-offs of politics, policies, and free speech. So while institution building will remain important, this turn of the rule of law focus toward people-centered justice really does promise a paradigm shift that offers a new and refreshing approach. And although I've indicated the ABA ROLI programs have long incorporated these principles, I think this shift of emphasis, it's a good time to treat this as an inflection point on what to do about the rule of law. But I do want to say that this focus on people-centered justice, I don't think should mean abandoning the importance of institution building. And perhaps it'll come as no surprise to you that, in my view, the judiciary remains a bulwark against arbitrary and capricious efforts and conduct by both the legislative and the executive branches. My message on rule of law backsliding is meant to spur us into action, not to despair. And I think it's an opportunity to really kind of step up to the plate and step up to the challenge. I have this funny little plaque I've had on my desk for years, and it says, when you're out on a limb, the world is at your feet. And I feel that's where we are with respect to the rule of law. Why are several hundred of us gathered here and more than 500 online to listen to these issues and important speakers today? Well, because I think we believe that there's hope. And I am personally inspired in that arena by my longtime friend, Dr. Mehmet Tank, a tax judge in Turkey. Now, he was in prison for almost 7 years. Why? Because he spoke out about the rule of law. I first met him through the International Association of Judges, where he was a frequent participant, and he was an eloquent speaker and writer on judicial independence. Here's his tweet to me in 2016, the last I would hear for many years. He says, arrest warrants were issued for 2,745 judges and prosecutors, including me, tax judge who was suspended. No more independent judiciary in Turkey. Now, a year later, the Turkish government confirmed that the number was actually 4,000. Dr. Tank was tried in his cursory trial. There were international observers there, but he was sentenced along with many judges and prosecutors. And then he was finally released in 2022. But he wrote to me that these former lawyers, prosecutors, and judges couldn't find a job. They were out doing the equivalent of driving Ubers or peddling in the streets. Their families and members of their families couldn't get jobs, banned from employment, and there were no social services available. So you can imagine the joy when I heard from him in February 2023, just a couple of months ago. He had fled the country, and he and his family landed in Switzerland, where they applied for asylum. And here's what he wrote, and I want to share with you. He said, exile, threats, injustice, and being imprisoned by my own colleagues has not diminished, but rather increased my commitment to the struggle for justice. It is no longer possible to ignore the threats around us and turn a deaf ear to the cries of victims. The greatest joy of a thinking mind lies in the struggle to elevate human virtues. In my mind, Dr. Tank is a testament to hope and perseverance, and his hope should inspire us all. So I look forward to this conference and learning how we can transform hope into action. Thank you.
Thank you, Judge McEwen. Let's have a round of applause for these inspiring speakers. I think they have set the stage for what's to come at this conference.